Today, we'll be talking about the United States Constitution, Article 4. Article 4 of the Constitution starts out with Section 1, the full faith and credit clause. So that reads, full faith and credit shall be given to each state to the public acts, records, and judicial proceedings of every state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. So when I use brown text, that's a direct quote from the Constitution. So this clause provides that state courts will respect the judgments of courts in other states. For example, a marriage or a divorce in one state is recognized as valid by other states. There have actually been a number of Supreme Court cases of, Jones versus Jones or something, a husband and wife arguing whether a divorce was legal or not. They went from the state they lived to Nevada to get a divorce and came back to the state they lived in and arguing whether that was a valid divorce or not. So, but in general, if you have a marriage in one state, it will be recognized by other states. Also, a debtor cannot avoid repaying a debt by going to another state. So this gives us, even though each state has its own laws and own court system, and they don't have to be the same as the next state, this still gives us kind of a unified judicial system so that we're a unified country, and you can't just, I don't need to pay my debt because I just now moved to Nevada, so sorry, that's a California debt and I don't have to pay it. We want a unified system even though we're not all the same between states. So this brings that unity without forcing conformity. This first sentence is very similar to what was in the Articles of Confederation. So it was an idea that they had in the Articles of Confederation and brought forward into the Constitution. And the second sentence basically says Congress can enact laws to specify what can be done so that, they can specify whether, in a court proceeding, evidence that was proved in one state court is valid in another, or a verdict in one state court has to be observed in another. They can work out the details in law, but in general, one state should respect the courts of the other. Section 2 continues with the Privileges and Immunities Clause, which states, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Now, this is fairly short and on the surface maybe doesn't seem to say much, but actually there's a lot packed into this that we might not recognize. So we have to go back to the ancient rights of free Englishmen, because this comes from common law in England. And the rights that were started with the Magna Carta in 1215 and developed over time, over many centuries in England, became to be known as these privileges and immunities. So free Englishmen as opposed to serfs who kind of belonged to the manor that they lived on. So first you had franchises and liberties. These were, the king could give a franchise or a liberty, giving a portion of his authority to a group to allow them a limited amount of self-government. So, this is like Middle Ages time. So maybe you had the, let's see, I don't know, the cart makers guild, and the king might say to the cart makers guild, which was the group of people that made carts, you can decide how to run your business, or you can make a rule that applies among you. So he would grant a little bit of self-government to certain groups. Being the king, he probably wouldn't grant much self-government, but maybe local rules making or rules within your group, your guild or what have you. So by this we get the meaning of franchise for the vote, in that it's a franchise is an amount of self-government. So by having the vote, we have self-government. So we term the vote the franchise. Also, immunities were exceptions from the king to certain obligations. It could be like the obligation to pay a certain tax to the king or to serve in the army or something. So the king as a favor to a group or something, could give a certain group immunity, say from a particular tax. Privileges were maybe not what we think of as privileges, but they were enforced by the courts, and there were various rights that free Englishmen were entitled to, including trial by jury, the writ of habeas corpus, which means that if you're detained or arrested, you have the right to challenge to a court whether your arrestment or detention is legal. So this prohibits you from being just arrested and held without charge, without trial. So if you're held without trial and without charge, you can file a writ of habeas corpus, and then habeas corpus means to have the body. You have to be brought before the court, and the court has to determine, is it legal to hold you, or if not, you're released. And if it is legal to to hold you, you have to be brought to trial, charged and brought to trial. So this prohibits the government from just locking up people it doesn't like. Lock them up, throw away the key, and don't give them a trial or a charge. Also, the right to use deadly force to protect one's abode, and the right to possession and inheritance of land. So a number of these got more explicitly put into our Constitution through amendments and such. Such as the right to use deadly force became the Second Amendment. Trial by jury is one of the Bill of Rights. But some, like right to possession and inheritance of land, we take that as a given, but it's not really explicit in our Constitution. So this privileges and immunities clause includes a lot of rights that, as in the English system, were just kind of inherently the tradition, but not explicitly written out. So we inherit a bit of that through this privileges and immunities clause. We've tended to specify things by writing them out more than the British have, but we still have inherited a large body of rights from English common law. In the American colonies, the privileges also included the right to travel and to move to another colony, and for merchants to carry on lawful trade in other colonies. So apparently Americans have always been on the move and traveling and moving around, but we wanted the rights to, and it developed over the colonial period that we had the right to carry on business or to move between colonies. And so because of this clause, states cannot discriminate against citizens of other states. And again, this was taken forward from the Articles of Confederation. Section 2 continues with the interstate rendition or extradition clause. So it says, a person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of that state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. Okay, so what's all this mean? Essentially, it prevents people fleeing from justice by going to another state. Can't commit a crime in California and then run to Nevada and say, oh, I'm in another state, nothing applies, you can't come and get me. So if you would do that, the asylum state would be where you ran to. That state's governor can only ask two questions. Is the person charged with a crime that violates the demanding state's law? And was the person present in the state when the alleged crime was committed? I guess in the time of the founding, to commit a crime, you kind of had to be there. So not like today, you might be able to commit it long distance, but it's not up to the asylum state's governor to determine if the person is guilty or innocent, just if they're legally charged with a crime and they were there, so there's a chance that they are guilty. So then they would be delivered up to the demanding state for trial. So the demand is from the governor of the state with jurisdiction, which generally would be where the crime had been committed. And today states cooperate on this to carry it out. And they may go beyond this, but this is what's required by the Constitution. Section 2 continues with the fugitive slave clause. Now, of course, today this really doesn't have an effect, but it's in the Constitution, and I thought we should at least, delve into the causes of it and why that was there. So, of course, at the time of the founding, slavery was practiced in the southern colonies, southern states. And so they inserted this clause: no person held in service or labor in one state under the laws thereof, escaping into another shall, in consequence of any law or regulation therein, be discharged from such service, but shall be delivered up on claim of the party to whom such service or labor may be due. So essentially, this is saying if you're held in service, if you're a slave in one state under its laws, you can't go to another state that doesn't have a slavery law and be automatically freed. So the slave owner can come and file a claim in court to bring you back and put you back into their service. So this was proposed by Charles Pinckney of South Carolina in response to a ruling by an English judge, Lord Mansfield. A case called Somerset versus Stewart in 1772, Lord Mansfield stated that slavery is so odious that no moral or political reason can support it except positive law. So he was saying you can't just assume there's a right to slavery because slavery is odious. It's terrible. So the only way that you can have slavery be legal is for a law to specifically state slavery is legal. And that he as a judge wouldn't just assume it was legal. It has to actually be stated plainly in the law. So he said, because it wasn't stated plainly in the law of this free colony where the slave is slave to, that he freed the slave. So this slave in that case was freed. So this alarmed the South because they thought, well, if our slaves escape to a free state, then they'll be freed automatically and we'll lose our slaves. So because of that, they wanted to insert this clause to say if they escape to a free state, they could still make a claim and bring the slave back. So this is Frederick Douglass was an early he was born as a slave and escaped and got his freedom and became an early abolitionist, advocating for the abolition of slavery. But his comment on this clause was it was the scaffolding to the magnificent structure to be removed as soon as the building was completed. So he understood that the southern states wouldn't agree to the Constitution without some sort of clause like this. So it was necessary, it was kind of a scaffolding that was necessary as they were building the magnificent structure, the Constitution. But he understood, he didn't like this, of course, but he said, it was necessary for the building, for the agreement of the southern states. But as soon as the building was completed, the scaffolding should be taken down. And indeed, today, this clause has no effect because no state has laws that allow slavery anymore. So, and also note that it stated the service was only under the laws of the state. So it says in one state under the laws thereof. So it was only sanctioned by the states, not by a federal government. So when the 13th Amendment, which abolished slavery, was approved after the Civil War, then the Constitution itself didn't need to be changed because there's nothing in the Constitution that says slavery is sanctioned by the federal government. Only particular states had laws that sanctioned it. Section 3 continues with adding new states. It says, new states may be admitted by the Congress into this union, but no state shall be formed or erected within the jurisdiction of any other state, nor any other state formed by the junction of two or more states or parts of states without the consent of the legislatures of the states concerned, as well as of Congress. So this is saying you can't split a state or join two states or make changes to states without the consent of those particular states involved, as well as Congress's consent. So Congress can set the rules for admission of states and can include provisions for entry consistent with their constitutional powers, such as preventing bigamy or who can vote. So these are within the powers of Congress, and these are actual constraints that they've put on different states or territories who are applying to be states. And new states submit its new constitution to Congress for approval. So it has to be something that fits with our constitution and the Congress is willing to approve. And new states are admitted on an equal footing with existing states. So the original 13 states on the eastern seaboard don't have any special privileges just because they are the original states. All the new states that have been added afterwards are equal in all respects to the existing states. So new states have been formed out of existing states' territory. So during the Civil War, West Virginia was carved out of Virginia, and also Kentucky, Tennessee, and Maine have been taken out of territory claimed by other states. Kentucky was claimed by Virginia, Tennessee was claimed by North Carolina, and Maine was actually part of Massachusetts. So so states have been, split and taken apart and made into new states. No state has been joined from two states, but we have had new states formed out of existing states. Section 3 continues with the Property and Territory Clause, which states the Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or property belonging to the United States. So this says Congress can make rules to organize territories to become ready for statehood. Back in Article 1, Section 8 and Clause 17, which is Article 1 is the congressional clause or article. It gives Congress the exclusive legislative power over the District of Columbia, which is our capital, and government properties. And it lists things like forts, dockyards, arsenals, buildings, etc. So they understood that there is a need for the federal government to control the capital, so it's not under the power of any one state, as well as certain government properties, such as for defense, forts and dockyards and arsenals, and other buildings, say courthouses or customs houses. So it gives Congress exclusive legislative power over those. However, a question that they didn't, I think, comprehend in the way that we have it today is the extent of federal power on on federal land. So not sure if you realize it, but actually 27% of the total area of the US is owned by the federal government. And in some Western states, it's really high percentages, like 84% of Nevada is owned by the federal government, 61% of Alaska, and in California, even 45% of the land is owned by the federal government. So there's a question of what's the extent of federal power on land they own within a state. So are they like an ordinary landowner? They can buy it and sell it, but not much more. Or are they able to pass laws protecting that property? Or are they even able to supersede state law? So superseding state law, maybe they would say people that live on our territory, our federally owned land within your state don't have to pay state taxes. If I could pass a law like that, I'd gladly exempt myself from California state taxes. But anyway, this is kind of a question that's been debated and is still somewhat open as to what's the extent of federal law or of federal power on land that they own within a state. Are they able to supersede the state of laws and authority, or to just pass laws for their own territory, or just like an ordinary landowner? Probably it falls somewhere in the middle of that, but there's been arguments towards the ends of that as well. Another kind of open question is, does congressional power change when a territory goes from a territory to a state, to property within a state? Because for a territory, Congress has pretty broad powers, but if they own property within an existing state, does that change their authority over that land? A third question is, does Congress or does the federal government are they supposed to retain land indefinitely? Because this says power to dispose of. So this seems to have been written with a view towards taking land and turning it into territories and getting them ready for statehood and letting them become states, not permanently holding land. So another open question here. The Northwest Ordinance was passed while the Constitutional Convention was going on, And that was addressing some of this question of the territory. The next sentence, it continues with claims. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. So there was a potential dispute over Western lands that were gained by the US in the peace settlement with Britain. Should they belong to the federal government or to the separate states? So this clause gave equal claims to both, equal weight to both claims. And Congress settled the issue through the Northwest Ordinance, which set up a framework for new states to be admitted to the Union. So we'll talk a little about this Northwest Ordinance. It was passed in July 1787 by the Congress under the Articles of Confederation. But that was while the Constitutional Convention was meeting, so they were aware of this. And it covered the area of the colonies west of the original colonies. So this area in here, east of the Mississippi River, north of the Ohio River, and west of the original colonies. So this was land that we had gained from Britain at the Treaty of Paris in 1783 that ended our Revolutionary War. But it had many overlapping state claims. New York claimed here down as far south as northern Alabama. Virginia claimed as far north as northern Minnesota. Massachusetts somehow jumped New York and claimed land over here in what became Michigan and Wisconsin. Connecticut would have claimed land that's now Chicago. So a lot of various state claims overlapping. And eventually they were kind of resolved because this area wasn't settled. States really weren't governing it in any real sense. So they eventually ceded it to the federal government and it became territories. And by the Northwest Ordinance, it organized a method for those territories to become states. So one of the most important provisions in the Northwest Ordinance was it prohibited slavery north of the Ohio River. So this was the first federal law to restrict slavery. And it shows the founders did vote to limit slavery. They understood it was a problem and did want to limit it. But in order to get the southern states to agree to things, they had to allow it to continue in the southern states. Interestingly, it also contained a version of the Bill of Rights. So our Bill of Rights didn't come until 1789, but in this Northwest Ordinance, they had a list that is similar to our Bill of Rights that was explicitly written out. So that idea was developing at this time. And it set up a three-step process to form new states, which became a template for other states to be added. First, the president appoints a governor, a secretary, and 3 judges to administer the territory. And then as the population grows, because generally these territories were not very settled at first, when the population reached 5,000 free adult males, they can elect a legislature and they can start to make their own laws for the territory. And then when the population reaches 60,000 free inhabitants, they can write a constitution and apply to Congress for statehood. So this gives, kind of a steady way for as the territory develops and gets populated, for people to start governing themselves, start self-governing by electing a legislature and then later writing a constitution and applying to become a state. So the Northwest Ordinance applied to the territory that later became Ohio, Indiana, Illinois, Michigan, and Wisconsin. And this, was a slow process. It was passed in 1787. It was 16 years before Ohio became a state in 1803, and 61 years until Wisconsin eventually became a state. So it was a slow process as we were expanding, but they set the model for the Union to expand. The final section is the Guarantee Clause, which states the United States shall guarantee to every state in this Union a Republican form of government and shall protect each of them against invasion and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. So as we heard earlier, we have a Republican form of government guaranteed by the Constitution, which means that government's accountable to the people. We have a democratic republic. So the democratic part is that we elect our representatives to the government. We're not a monarchy, which the founders certainly didn't want us to be, since we just revolted against Britain, which was a monarchy. And we have the rule of law. So all are subject to the Constitution and the laws, not the whim of the mob. The founders specifically didn't want a pure democracy where 51% of the people vote for something, they can say, the 51% say, we're going to take all the property of the 49%. In a pure democracy, there's nothing to stop that, but we are a constitutional republic, so we have laws that protect not only the majority, but also the minority. So that's the important difference between a republic and a democracy, is that even the minority is protected by our Constitution and laws. And it protects from invasion and domestic violence. So they wanted to make sure that all states were protected equally against invasion, and if there's domestic violence, that they can ask for the federal government to come and help restore order from domestic violence. So in conclusion, Article 4 governs the interaction between the states, incorporates the rights of free Englishmen for all citizens. And if you're fleeing to another state, it doesn't let you escape the effects of the justice of laws. So we can have kind of a unified, although not unified but not uniform system of justice across the country. And it allows for the addition of new states to the Union on an equal footing with the old states. And Congress has control over territories and federal property. We have a guarantee that each state must have a Republican government, and the federal government is also a Republican form of government. And it protects states against invasion and domestic violence. And that covers Article 4. Thank you.